Hello, everyone. This is Stephen Richardson. Today, we're going to be talking about a July 2013 California bar examination. It was question 2 on that test, and it was a constitutional law question. So let's jump in. This is not legal advice. I'm not giving you legal advice. This is purely and solely to help law students pass their law school exams and bar exams. This is the information that was provided on for this test, the Cal Bar exam, just general information. Today, we're going to use materials, products from lawschool-essentials.com to go over this outline and an IRAC for these issues. And they are mnemonic memory guides to help you memorize. You have to have the checklists and the black letter law memorized, and we use mnemonics to help do that. So here we go. First, you read the call of the question. What arguments can Pete or his parents reasonably make in support of their action, and how should the court rule on each? So, how should the court rule on each? All right. The legislature of State X, so this right away it tells you constitutional law, recently completed a study on the behavior of teenagers residing in the state to reveal the connection between an increase in the school dropout rate and an increase in the level of criminal activity. The study indicated that the connection was most pronounced among boys ages 15 to 18 years old. Troubled by what it perceived as a breakdown in personal responsibility and social order among its teenagers, State X's legislature has enacted a statute creating the State Forestry Corps. The Corps drafts boys ages 15 to 18 who have dropped out of school. It sends them to camps located on public lands administered by the State Forest Service. It also provides them with a comprehensive education leading to a high school diploma. To defray a portion of the cost, the Corps requires the boys to work on reforestation projects for a few hours each day. Pete, age 15, has dropped out of school and consequently has been drafted into the Corps. Pete and his parents have filed a declaratory relief action attacking the validity of the statute under three provisions of the United States Constitution. One, 13th Amendment's involuntary servitude clause. Two, the 14th Amendment's due process clause. And three, the 14th Amendment's equal protection clause. So as you're reading this, you start to think, okay, Pete is an individual. He's the proper plaintiff, and the proper defendant is state government, right? Justiciability, injury in the zone of age, and dropout. Okay, so it looks like this is just justiciable. Mootness, there's a genuine dispute, and ripeness. Draft either has occurred or will. Well, it says it has occurred, so I don't know why I put as imminently. It has occurred. So, 13th Amendment, did Pete commit a crime? No. So, involuntary servitude would be authorized if Pete committed a crime. Anybody gets a diploma for working. Free room and board for Pete. Okay. 14th Amendment due process, proper reason for regulating his personal responsibility and social order. 14th Amendment equal protection, children, intermediate scrutiny. Children are not exempt from these analysis, or they don't get special favor. So you should be thinking about that. Also think about our other children each created same way. Here we're talking about boys. What about girls? What about Amish teenagers? Amish teenagers, they stop going to school at eighth grade after eighth grade. Okay, and then you need to think about states are not immune if states are immune to lawsuits by their citizens, but if Congress enacts a law that could pierce the immunity, and we're talking about discrimination. So if you can show that boys are discriminated against girls, that might be a valid talking point. Okay, so here's what the checklist is going to look like. Always discuss standing, mootness, and ripeness first. Always discuss it. Okay, so private plaintiff, injury in fact caused by the government. Can the injury be redressed? Yes to all questions. Don't think there's a mootness or ripeness, so quickly talk about it and move on, right? So 14th Amendment, depriving person of life, liberty, or property without due process. We're not talking about we are talking about substantive, not procedural. This is substantive due process. state intrusion, 14th Amendment. Okay. Uh, s- and here's the standard of review: strict scrutiny or intermediate scrutiny. And then equal protection of the law, where state law treats a person or class of persons differently from others. You're going to have to look at facial discrimination, discriminatory motive, suspect classification, which probably doesn't apply here. Discriminatory motive, maybe. Facial discrimination, maybe because of boys versus girl teenagers. Um, Not a discriminatory application. Quasi suspect classifications. Um, Distinctions between legitimate and no, that doesn't apply either. Um, okay, so your outline is going to look like standing, mootness, ripeness. Um, then for the plaintiff, you'll talk about 13th, 14th Amendment, and then you'll give a conclusion. And and we'll move on from there. Okay, so justiciability. So first off, you want to state that a plaintiff seeking declaratory relief must show that there's an actual controversy, even though declaratory relief will not order an enforceable action against the defendant. An actual controversy means there is connection between the challenged conduct and injury and redressability that the court could order. Okay. Um, the controversy that you got to have this memorized to regurgitate it. So we'll go to the analysis. Pete's liberty is threatened by being drafted by the state to go to a forestry work camp. Pete has, in fact, dropped out of school and is in imminent peril while he was drafted. The state's legal interests of drafting Pete are adverse to Pete's freedom. Pete's imminent injury can be redressed by voiding the state laws requiring the draft, right? And then your conclusion for justiciability, and then mootness and ripeness, boom, boom. So this should take you about 4 minutes to do this. Okay. And then the issue for mootness, issue for ripeness, this again is 4 minutes. So 8 minutes total for justiciability, mootness, and ripeness. Okay, we'll move right on to the meat here. This is the 13th Amendment. 13th Amendment says neither slavery nor involuntary servitude, except as a punishment for crime, wherever the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Right? This state law appears to be involuntary servitude by coercion through law or legal process. Um, Involuntary servitude was intended to cover those forms of compulsory labor akin to African slavery. Immigrants, children, and mental incompetence are not entitled to any special protection. Courts are most likely require an intermediate scrutiny standard of review for alleged violations. Pete has not committed any crime. Schools are provided and paid for by taxpayer dollars, whether or not a taxpayer has a student enrolled in school. School is voluntary, as evidenced by homeschooling. However, even though state is providing an education, room, and board in return for working a few hours per day at the resident camp, it may appear as servitude because no wages are being paid, and Pete was drafted against his will. So here's where you're gonna need to make an unbalanced decision about whether this violates involuntary servitude. Um, and you might be able to compare it to military service, military draft. In the military, soldiers, servicemen, and women are paid for working in the army. You might want to discuss that. Okay, due process. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive the person of life, liberty, we're talking about liberty, or property without due process of law. So a violation occurs when a state law interferes with fundamental constitutional rights, in this case, liberty. Moreover, the 10th Amendment allows all powers to the states not specifically forbidden in the Constitution. SCOTUS has held that when acting pursuant to legislative power, Congress can abrogate the state's immunity from suits. Here would be discrimination based on sex, boys and girls. Um, State action is adverse to fundamental rights, such as liberty, must meet strict constitutional scrutiny for due process. Pete must show the statute furthers no legitimate state interest or that the statute is arbitrary. It's going to be hard for him to do this because it does further a state interest, and it is not arbitrary. They had a study, and it's targeting teenage boys ages 15 to 18 who are dropouts. So I don't know that Pete is going to be able to prove this that it's a violation of due process. Okay, moving along to equal protection. This may be a strong argument. No state shall make or enforce any law. I already read that. Nor deny to any person within its jurisdiction the equal protection of laws. Okay, a violation occurs where a state treats a person or class of persons differently from others. So here is where you could state that boys and girls are treated differently. Amish teenagers, are they treated differently? Um, Remember to discuss facial discrimination because on its face it looks like it. Explicit distinction and other classifications, age and sex. Um, discuss quasi suspect classification, targeting boys ages 15 to 18 and not girls. Um, but again, the state has a legitimate claim, a valid claim about reducing criminality and increasing social order, so forth. Okay, so this pretty much wraps up this look at this constitutional law exam from July 2013 California bar exam. If you liked what you saw, click subscribe. Tell your family, tell your friends, tell your enemies, tell your fellow students. Click subscribe. And we'll be putting up more questions for Cal bars and first year law student exams. Thanks and see you on the next one.